Further hearing in the appeal, Secretary of State for the Home Department against Franco Vomero.
Yes, Mr. Palmer. I would have... Who do we think goes first?
My lady, my lords, Mr. Palmer and I have had discussions, and he's kindly agreed that I can go first. I have the burden of persuading you that a conclusion which you reached isn't correct. And although I'm a respondent in the case...
Exactly. And there are at least there are at least five possible solutions to the conundrum in this case, and
yes.
you stand every chance of getting 5 answers.
I'm very happy to go as the court would prefer. So,
I don't think we have a view. I don't think we have a view. It's entirely...
We had agreed in communications between us and...
Well, what you had agreed, we will go along with.
That's very kind of you, my lady. Thank you. My lady, my lords, as you know, I appear with Professor Tridimas, Mr. Armstrong for the respondent, Mr. Vomero. My learned friend, Mr. Palmer, appears for the Secretary of State. At the outset, may I extend our congratulations to Mr. Palmer for his, if I may say so, much-deserved elevation. Might I be forgiven for saying that his elevation is, of course, presently virtual, albeit no less real, crystallising next month. I hope Mr. Palmer will forgive me for that.
Well, we're going to do the same, Mr. Hussain. So,
and the court.
Can we second those congratulations? And of course, entirely due to your performance in this case.
No surprise, my lady, at all, if I may say so. My lady, my lords, the remaining issue in this appeal concerns the question whether Mr. Vomero necessarily lost, in a virtual sense, as we would say, or necessarily failed to acquire, as Mr. Palmer would say, the right of permanent residence by the date of the decision to deport him in March 2007. As the court is aware, we say no. RPR is not automatically lost by reason of a bright line rule on service of a prison sentence in excess of 2 years. May I just clear some decks? There are 4 items of common ground which you've set out in our supplementary submissions at tab 10. I hope you received the letter from those instructing me indicating that yes, they were our composite submissions and you could just go to that document. But the document is set out at page 1100, electronic bundle, tab 10. And we've set out the common ground at paragraph 3. 4 items of common ground. Mr. Vomero is false to be treated as having acquired at least 5 years continuous residence in accordance with EU law. And I've given you the references in the footnotes as to where we get that common ground from. I think Mr. Palmer agrees. And therefore, Lord Mance's summary that it was accepted by the Secretary of State, Mr. Vomero had by 2011 established 16 years of residence, is to be taken as an acceptance that such residence was lawful. The sole basis, the third point, the sole basis for the view that he didn't have an RPR in 2007 is that set out in my Lord's reasoning at 7 to 12 in the Supreme Court judgment. It's essentially imprisonment plus the case law. 5 years imprisonment plus the effect of dias and on acquire. And then lastly, it's open to us to argue on remittal. We both agree there should be a remittal. The contest is as to the terms of the remittal.
Can I just ask you about that? When we last met, you were seeking a dismissal of the appeal. Why has your case got weaker?
Because you have...
Is it because of our paragraph 12?
No, because we don't say that we necessarily enjoy RPR. We say it should be open to us to argue that before the tribunal in 2000.
Was it given in the Court of Appeal that you had RPR?
Yes.
And the Secretary of State was not allowed to appeal against that. It's a given, in my opinion, at the moment.
My Lord, I think the position is that the Secretary of State wasn't allowed to contest the quality of the residence until 2001. but then the issue of the legal impact of imprisonment.
That's an issue before the Supreme Court.
That was.
We might have all packed bags and gone home if that
issue,
wasn't an
yes.
issue.
I would very much like to agree with you, my lord, but I don't think I can.
It couldn't be clearer from particularly Lord Justice Akins's judgment that RPR was a given, and that when he looked to see what the argument before the upper tribunal had been about enhanced protection, the Secretary of State made no issue about 10 years residence. Correct me if I'm wrong. The only issue was whether there were imperative grounds of public security.
That's absolutely right, my lord.
And so much of this, on mature reflection, has been decided and coned off. And the trip to Luxembourg, interesting though it was possibly on an entirely unnecessary premise. You seduced us, Mr. Hussein, into thinking that it was arguable that for enhanced protection you didn't need permanent residence. In fact, you'd got permanent residence. But anyway, you raised that point. Well, some of us thought it was a very good point, and so off to Luxembourg. And the answer has come back that on that particular point, Mr. Hussein, you were wrong.
Yes, the minority's view was right on that point. The difficulty I have is that in the judgment, at paragraph 24, the court concluded that the Court of Appeal's examination of the issue couldn't stand because it was conducted on a basis that was erroneous, paragraph 24. I think there was some focus on the idea that the respondent had acquired right of permanent residence before 2006. I tried to argue that that was simply a shorthand. But
in the December letter, it was made quite clear that no order having been made upon our reference judgment, there was nothing binding about it.
Indeed, my lord. Our understanding is that the issue that was closed off by paragraph 35G of Lord Justice Pill was that it was too late for the Secretary of State to put an issue quality of the residence until 2001. The Secretary of State was granted leave on the legal effect of the 5 years imprisonment. May I reflect on this? It's obviously a point in my favour.
No, Mr. Hussain, in order to examine this, we have to do what I thought I could do from the present bundles, but which I've certainly recalled doing, and that is tracing the submissions at the first stage before us. And you argued then all the points that you're developing further now.
I did.
Now, there would have been absolutely no point in that if the issue wasn't open, and you then re-argued them after you'd lost before us in the European Court.
I did.
So, I mean, I credit you with not having overlooked some obvious point.
Can I may well have done, and I don't want to foreclose that.
You've got very limited time. I'm sorry, my suggestions have taken a few minutes of it, Mr. Hussain. You carry on with your planned submissions. You forget what I've said.
No, not at all. It was something that occurred to us way back when the court granted leave. Absolutely.
Yes.
But, my lord, I have 5 points.
I thought we did.
5 points.
5 points. First, the bright line rule for which the Secretary of State contends, in which the court concluded existed, is inconsistent with the Grand Chamber decision in this case and the Advocate General's opinion.
Yes, exactly. Yes.
The court doesn't just leave the issue open. If one analyses it, it's clear it's absolutely inconsistent with the existence of a bright line rule. I'll develop that. Obviously, that's the basis on which my lady, my lords, sought further submissions and a further hearing. Second, such a bright line rule is inconsistent with previous Grand Chamber authority in Sakaridis and PI. Third, there is a difference in principle between what we have called Category 1 and Category 2 cases. That is to say, a difference between cases, on the one hand, where 5 years pre-transposition have been accrued, and the question is whether RPR is lost, or that's been virtually acquired, is then notionally lost by reason of an intervening event, absence, reliance on social assistance, or imprisonment. And on the other hand, that's one class of case, on the other hand, where 5 years pre-transposition residence has not even been accrued. The fourth point is that whilst imprisonment appears to attract a bright line rule in the Category 2 case, see Onoquere, the better view is that it doesn't do so in Category 1 cases, given the absence of clear language to that effect, the view of the Grand Chamber as to the nature of imprisonment, in our case, or the linked case of B, and Sakaridis, and the now established interrelationship between RPR and enhanced protection. And then the fifth point is that a bright line rule in Category 1 cases has the potential to undermine the effectiveness of the right of enhanced protection against expulsion in Article 28.3a. It's the deferred decision point. So may I develop the first point then? We say the bright line rule is inconsistent with the Grand Chamber. First of all, our submissions, pages 1109 to 1111, paragraphs 36 to 41. I'm going to just refer to those January submissions at tab 10. May I ask you to take up Vomero in the Grand Chamber, please? It's Authorities 3, tab 18. So we've got it in the weeklies. It hasn't yet got to the law reports. The facts are set out at page 1167. Sorry, that's an error. It's at paragraph 28.
Yes. Very well.
Sorry, I'm right. I'm the Advocate General. I'm so sorry. So 1167. The facts are set out. The Secretary of State's argument in support of the bright line rule is set out at paragraph 34 on that page. And the court's reasoning and conclusion on this issue is set out at 35. And you'll see that the Grand Chamber records this court having referred to LaSalle, Dias, Onoquere, considering that since no right of permanent residence could in law be acquired before April 2006, we accept that, of course, and since it's common ground that at that date Vomero had been in prison for more than 5 years, he remained in prison for a further 2 months, etc. He had not acquired a right of permanent residence under Article 16.1 when the decision to deport was adopted. So they've summarised the reasoning. That's essentially, my lord, at paragraph 7 to 12. It's basically the effect of those decisions plus more than 2 years imprisonment before 2006. And then we see over the page consideration of the first question. This was the question of whether or not RPR was a necessary precondition to enhance protection. And at paragraph 41, the court notes that the question, that's the referred question, is based on the premise that Mr. Vomero doesn't have such a right of permanent residence. And then this is the critical paragraph. Since the court doesn't have all the information necessary in order to assess the merits of that premise, it must be assumed, for the purposes of the question, that it is well-founded. Now, we have said that that is an unusual statement. We're not aware of it ever having been appearing before in a decision. Professor Tridamas isn't aware of this. My learned friend hasn't pointed to anything that comes to light for him, and has not contested it's unusual. Now, 42 begs the question, what was the information that the court did have? And we say it's pretty clear from looking at paragraph 35 and from looking at the judgment of this court. The information it had was imprisonment plus bright line rule.
Is it possible that they might be referring to the absence of information about the period since 2007?
No, that's... may I come on to that?
Yeah. Yes,
that's obviously my learned friend's point. In a nutshell, I can say no, it's very obvious. They were taking the material date as the material date in the referred proceedings, which was March 2007. When they wanted to look at post-March 2007 events, they made it very clear. If you look at the end of the judgment around paragraph 88 onwards, in particular 91 and 93, they consider the effect of Article 33 of the directive. And it's very clear the language is completely different. They expressly address post-2007 events, but I'll develop that. So the information it had here that was not sufficient was the reasoning summarised in 35, which is that my client was imprisoned for more than 2 years, 5 years, from 2001 to 2006, and there was a bright line rule.
Well, bright line rule wouldn't be an information, would it? It's a proposition of law. Whether it's right or not is the question you're wanting to debate.
Well, it's a loose...
But they're talking about an absence of information.
Yes.
Presumably factual information.
My lord, with great respect, I can live with that, because I can say that the information that he was imprisoned for 5 years, from 2001 to 2006, was not enough. Why isn't it enough? Because there is no bright line rule.
Or was the information that he'd notched up more than 5 years prior to 2001?
Yes, of course, but the burden on me at the moment is to establish, this the argument that we have run on this issue always, is that there is no automatic loss. We don't say it's not relevant. Of course it's relevant, but we just say it's not automatic. You'd have to have very clear language to show it's automatic. You haven't got that. And then, my lords, interestingly, my learned friend, with respect to him, says in his submissions at paragraph 6, these are his December submissions at tab 9, pages 1088 to 90, he analyses the case law in this, if I may say so, broadly in the same way as my lord did, and you have that at his paragraph 5.
So what was the page number again?
1088 to 1090.
That's right.
Where he looks at LaSalle, Dias, and Onoquere, and he says at paragraph 6, the above analysis is fully reflected in terms of Lord Mant's judgment. But with great respect, that is the analysis which did not supply all the information, I'm quoting, all the information necessary in order to assess the merits of the premise. It wasn't enough. It led to assumed rather than established correctness. More information was needed. What information, one might rhetorically ask? We would say information concerning the retention of integrative links. Those links were not necessarily destroyed by that term of imprisonment. And so we say that statement at 42, the assumption of the premise rather than its established correctness for the reason given that the information wasn't enough is absolutely inconsistent with the existence of a bright line rule. If there was a bright line rule, there is no way on earth the court could have said that. And nor can my learned friend get anything from the fact that they say the premise must be assumed to be well-founded. That just amounts to saying it must be assumed to be the case. That last clause is governed by the preceding clauses, the absence of sufficient information and an assumption. And this is not at all surprising that it said this, that in effect said that the existence of a bright line rule and the term of imprisonment was not enough for it to definitively conclude that there was no right of permanent, the right of permanent residence that would notionally have been acquired before 2006 had by then been lost. And this is, I say it's not surprising, because when we look at its treatment of the nature of imprisonment, firstly, and the impact of imprisonment on integrative links that have been previously forged, we see that it, unsurprisingly, we say with respect correctly, sees imprisonment as multi-dimensional rather than unidimensional. It depends whether or not you lose integrative links that you previously acquired.
It does that, doesn't it, in the context of what I'll call the 10-year condition?
Absolutely, my lord. Of course.
You say you can read across, do you?
Absolutely. And the reason we can read across is because the observations here are to do, as I said, with the nature of imprisonment in general and the impact of imprisonment on the retention or otherwise of previous integrative links. And that is a cognate analysis across 28.3a and 16.4. If indeed not the same basic idea that it is at work. And if we look at...
Doesn't that face a problem which was identified in this court's first judgment, namely that there are passages in at least two cases, MG, the court, paragraph 37, and Advocate General Bott's opinion, paragraph 28 in Honour Query, which actually distinguish the 10-year integrative link from the position under Article 16.4, which is applied by analogy in the present context. They actually say that they're different concepts. So as to read the same, as you just said, approach into Article 16.4, whether it applies directly or by analogy, is perhaps rather difficult, or at least not obvious.
Well, I accept that there are those observations. We would say that they don't... Here, the fact that the court is looking at these issues in the context of Article 28, the tests are different, they're not the same, I accept that. The wording is not the same, but the issue here can be transferred across, we respectfully submit. MG, by the way, doesn't say for a moment that imprisonment beyond 2 years destroys RPR. The Secretary of State accepted that, or enhanced protection. It was a case about enhanced protection, I accept that. The issue didn't arise, but it doesn't say that. But can I please go to paragraph 71, where the Grand Chamber says, particularly in the case of a union citizen who was already in a position to satisfy the condition of 10 years continuous residence in the host member state in the past, even before he committed a criminal act that resulted in his detention. That is, of course, us. We had 16 years, not just 10. The fact that the person concerned was placed in custody by the authorities can't be regarded as automatically breaking the integrative links that the person had previously forged with the state.
For the purpose of Article 28.3.
Indeed, my lord. I'm simply showing...
That's the question, isn't it? Is whether you can read this across to the 5-year condition in the right of permanent residence, which is Article 16.
It is. The structure of my submission is look at 42. 42 is flatly inconsistent with the existence of a bright line rule. If there was a bright line rule, it's common ground, it's met. That's why we're here. it's met. The question is, well, are there any clues in the judgment as to why they said that? And we say that you get it from 71, and where firstly they say that you can't have an automatic break, except for the purposes of Article 28, and that if you had that, letter D, such an interpretation would deprive that provision of much of its practical effect, since an expulsion measure will most often be adopted precisely because of the conduct of the person concerned that led to his conviction and detention. So we would submit, should the Secretary of State be able to sidestep the rejection of an automatic rule in the Article 28 context by simply saying that after 2 years imprisonment you have automatically lost RPR, which we now know is an essential prerequisite for enhanced protection. And we say, of course, no, the Secretary of State can't do by the back door what he is prohibited from doing by the front. And I do invite my lords, my lady, to look at, in his printed case, the Secretary of State thought that he was required to wait at least 2 years before making a decision to deport. I'll give you the reference. It's an extraordinary position to take. But that was it's there in terms. And it's there at pages 122 to 23, at paragraphs 66 to 67.
So
of
one
printed case.
22.
66, 67, pages 122 to 3. And our submission here is that once you have the idea or the rule that RPR is a necessary prerequisite, would your Lordship like to look at that? The Secretary of State.
Yes.
66 to 67. The 67, the requirement that the member state wait until more than 2 years have been served benefits the citizen. Whilst a member state must defer any expulsion decision until more than 2 years in prison have been served. It's not the deferment which defeats the application, etc. So that's where we are. And when you look at what the Grand Chamber says in 71, we say that's clearly impermissible. You can't do by the back door what you're prohibited from doing by the front. What I was saying is, once you have RPR as a necessary prerequisite for enhanced protection, and the issue we're debating today, RPR automatically being lost on 2 years imprisonment, you then have a colossal rigidity in the availability of enhanced protection, which clearly the Court of Justice is anxious to avoid. Everything it's said is the antithesis of that in this context.
Yeah, if you just ask, if you win on this point, how does the position stand in respect of enhanced protection?
We may get it.
Well, you may,
yes.
But whether you get it depends upon how enhanced protection works, how the requirement of continuous 10 years. Yes, but that's a separate point which we actually referred to the European Court on an assumption, admittedly, that that the initial 5-year protection was not necessary, but it still arises if the 5-year protection is necessary, doesn't it? Assuming that the integrative link operates differently in the two contexts, which has been said, as you accept, in several cases. And the reason it operates differently is that the requirement of continuousness may also operate differently.
Yes, but that's not an issue
Well, no, but I'm just wondering whether we wouldn't actually have to grapple, maybe not today because it's not being argued, but some court would have to grapple with what the 10-year continuous period meant and how it operated, and raise parallel questions to the one which we previously referred to the European Court and didn't get an answer to.
Well, you didn't get an answer to it.
No.
We didn't get an answer because they said it didn't arise.
Yes, right.
Because we lost
I know,
the
but
issue.
all I'm pointing out...
The sister case of B did.
Yes.
And if you look at the
right.
operative ruling
Yes,
in B, it's basically the nuanced approach. You look at the 10 years, it was more or less what my Lord Reed was actually putting to be.
Yes. So you say it's all sorted out by the sister case?
Basically, it is. You basically look at the 10 years, and the touchstone is overall assessment.
But assuming, if I've got it right, what you're saying is that in their answer to the associated case,
yes,
B,
yes,
Luxembourg court dealt with how you approach the calculation.
Oh, absolutely.
What I call the 10-year condition.
Yes.
And required what I think it calls an overall assessment of integration, etc. But what do you say is the position in relation to this man's 10-year condition?
Well, we say that
has that overall assessment been carried out?
It would need
in
to be.
accordance with the way that the Luxembourg court wants it carried out, or hasn't it?
Well, I tried to argue that it had, and I lost before you last time round.
So that's got to go back as well,
that's got to go back. Yeah.
Okay, thank you.
And the question is, what we're arguing about now is that, is it open to me to argue before the upper tribunal that he didn't automatically lose his...
No, I know what you've explained what point you're on, and you've now told me what your stance is on the 10-year condition, so I've got it. Thank you.
Then that would be a platform for the argument that actually he's got his enhanced protection. But if I don't win that, then I can't argue for RPR, at least in 2007. I have to rule that out, and Mr. Palmer graciously lets me...
Then you lose, obviously, yes.
Well, Mr. Palmer kind enough to say, well, I can argue it as of today. But obviously...
I must confess I don't understand that either, though I expect it's just me. I thought that the question in issue in this case was the validity of the decision made in March 2007.
That's the first way of looking at it, but because of the tribunal's jurisdiction and the fact that more than 2 years have passed since the initial decision, under Article 33 of the directive, you then shift the analysis.
Okay, thank you.
But it's very material for us to be able to argue that he had an RPR in 2000.
Yes, of course it is.
So, for obvious reasons. But the rigidity to which I was referring is especially dramatic if, as the Secretary of State floated, and as my Lord Mance seemed to contemplate in paragraph 11, that you could have a loss of RPR in a non-transitional case for reasons other than absence, despite the fact that 16.4 says shall be lost only by absence. It was floated by my learned friend, based on an inquiry, and contemplated by my Lord with great respect to him, that ignore the language of only, you could broaden it out. Now, if that gets traction anywhere, then the results are incredibly dramatic. Because in any case, not just transitional cases, you have 2 years plus imprisonment. Secretary of State waits for 2 years. He thinks he's required to wait, let alone having the ability to do that. He waits, that's it gone, enhanced protection gone at a stroke. Forget about the overall assessment that the Grand Chamber says you still have to perform. And these nuanced observations about the nature of imprisonment, forget about all of that. That's gone. Because you haven't got RPR by reason of a bright line, rigid rule. And then the court also looks at, so that's the interrelationship issue. The Grand Chamber looks at the nature of imprisonment and in particular its rehabilitative purpose, which contraindicates, we say, a bright line, at paragraph 73 to 75, where it endorses the observations of the Advocate General.
I mean, you say that one can't apply Article 16.4 by analogy in circumstances to which it doesn't apply, but that's contrary, isn't it, to Dias, where it was applied Not in a case of absence from the jurisdiction, but in the case of someone who, although he had a residence permit, didn't actually have a right to reside under EU law.
Yes.
It's also contrary to honor query, where they applied Article 16.4 by analogy to a case of imprisonment. Didn't they?
Not at all, with great respect. Honor query has got nothing to do with 16.4.
Well, it refers to 16.4. It refers to the passages in Dias.
The case itself, that is paragraph 26, which the Advocate General says cannot be applied to Dias. The case itself is about 16.3. They apply 16.3 because honor query never accrued his 5 years. The Dias issue, my lord, Dias, you say, apply 16.4 by analogy. Dias is an extraordinary case because in Dias, what you've got is reliance on social assistance, income support. You've got to restrict that to pre-transposition cases, because if you apply that...
Well, that's pointed out in our previous judgment, isn't it?
Yes, you make the point that if you apply that post-transposition, it defeats the very object of RPR. The very object of RPR, well, it has a dual function now. The primary function of RPR is to relieve the individual of the duty not to be a burden on social assistance. That's the very point of it. That's what Dias is about. Dias says, yet you can rely on that to have the result, for RPR to be lost. The second function of RPR now is that it's a gateway to enhanced protection. But in Dias, my lord, if the court was trying to set up a bright line rule in the context of social assistance reliance, the very thing which RPR is supposed to excuse you from, if it was going to be doing that, it would not have used the language called into question, affected. It would have said destroyed, which is the language that we see in Vomero. If you look at paragraphs 73 to 75, the language they're using is the language of destruction of links. That's what you need. If you've got an automatic bright line rule.
Have we looked at the other linguistic versions of the judgment? I mean, you're attaching a lot of weight to quite a fine verbal distinction.
Well, called into question, the ordinary meaning is raises an issue, raises a doubt.
One thing about Dias is that it does show that there is a fairly fundamental difference between acquisition, or the position before the implementation date, 30th April 2006, and the position after. Because as you pointed out, after,
yes.
If you have 5 years which accrue after 30th April, then 2 years imprisonment isn't, or 2 years, sorry, 2 years non-residence in accordance with EU law is irrelevant because you've acquired your right. But before, it's critical.
Sorry, 2 points, if I may. We know from LaSalle, paragraph 31, that the directive must not be restrictively construed. We know that, first point. The second point is, LaSalle actually says, that's 31 of LaSalle. LaSalle at 56 and 57 says you've got to apply 16.4 independently to pre- and post-transition cases. And that was the view of my Lady Justice Arden in the referring court, as she then was. We've got her, we've cited her. She said the same thing. Luxembourg court said the same thing. And Dias clearly marks an inroad into that. Of course it does. The question is, do you expand that inroad and blow 16.4 completely open and allow it to apply to everything, or all conduct that is not legal residence, not just absence? And do you allow it to establish an automatic bright line rule? Or do you construe it narrowly? And we say you construe it narrowly. Not least because we have the Grand Chamber in our case.
Well, that's an interesting question. I'm just wondering to myself how one would write a judgment. It's sometimes difficult enough to construe an answer which the European Court gives to a question which is put, but this is an answer to a question which wasn't put, and it's a pretty opaque answer.
My Lord, but my friend floated that idea that somehow there was something wrong with that. There's obviously nothing wrong with that.
What is different, I don't say it's wrong, is that it's in no way binding on us. It's not a question which was referred to the European Court, and it's not a question which they purported to answer. They, I think, were, maybe you say rightly that they were giving a hint, but...
It's more than that.
All right, you say they were giving more than that, but it's still not binding on us, is it?
I'm not sure that's right. I'm not sure that you can...
The only thing that's binding on us is a question which we've referred.
I'm not sure, but I'll try and reflect on that. But you may well be right. You probably are, but may I reflect on that?
Yes.
But if your choice is to just brush aside an inconvenient Grand Chamber decision in Vomero, to brush aside two inconvenient Grand Chamber decisions in Sakaridis and PI, I agree in those cases the point wasn't put, they didn't consider, I accept that. But there is something to be said for construing the jurisprudence of the European Court consistently. So if there's a choice of just ignoring those decisions on the one hand, and on the other hand, reading a great deal into Dias and on Aquere, then you have our submission on what should prevail. May I, to rehabilitative purpose, may I just give you the references, 73 to 75, paragraph 83, and operative paragraph 2. And the pages are 1175 and 1081 in Vomero. And then the point, I'll just come to a point that Lord Reid put to me. My learned friend says two things about Vomero. First of all, he says that the court received conflicting submissions on the point and left the issue open. We argued, we didn't argue for retention of RPR. We said there wasn't an automatic rule. And if you want the references, you'll have them at pages 1029 to 1033. Those are our submissions before the Luxembourg court. We weren't saying, we're definitively, we've got it. We're just saying, look, an automatic rule is wrong. The commission, represented by Mr. Wildschpin, my lady may recall that it's not the first time I've disagreed with Mr. Wildschpin.
If I may say so, his submissions are, I think, the only European document in this case I've found perfectly clear and easy to understand.
It's often like that in court as well. But we've had some interesting views on the CS case. I don't know if my lady may recall.
His analysis arrived at the same result as the court had
as this court
had in its
yes, but not what the Luxembourg court says in the Grand Chamber says in 42. Yeah. My learned friend says the court didn't address the point either way. Well, we resist that. He says that in paragraph 16 of his submission, because clearly what the court said isn't consistent with the bright line rule. It's consistent with the absence of a bright line rule, and it's consistent with more information being required to assess the merits of the premise. And then the temporal point that my Lord Reid put to me, we say, the first point we make is the Secretary of State doesn't specify whether the current date, the present day date, is the date of hearing before Luxembourg in July 2017 or the date of judgment. But we nevertheless address this at paragraph 41 of our submissions at page 1111. We say this is a highly strained reading of those paragraphs for a number of reasons. It involves reading in the words in brackets that we've identified. Can I just ask you, please, to this is our paragraph
17A.
Thank you very much. 17A.
Forgive me. 41A.
41A. Page 1111.
What they're saying is right. They'd set out at paragraph 35 what this court had concluded in the last two lines, that Mr. Vomero had not acquired a right of permanent residence when the expulsion decision was adopted.
Yes.
And then the court was asking whether he qualified for enhanced protection against expulsion. And the court then raises as a preliminary point, it should be noted that the question is based on premise that he does not have such a right of permanent residence.
Yes, but that's referring to the question. And the question is taken from the National Court proceedings. And so the material date...
Well, we're told that they've reformulated the question in paragraph 40. And that's the question that they're talking about, their reformulated version of it. So, as they've put it, the question is whether the person concerned must have a right of permanent residence before he has protection against expulsion, enhanced protection. And they say, well, the unstated premise here is that he doesn't have a right of permanent residence. And that's entirely consistent with accepting that he didn't have one on whatever date it was in 2007 when the decision was taken, but that 11 years had passed since then.
But there's no hint that that's what they're referring to. I would accept that's just about open on a textual analysis. There's no hint of it because you look at the information that they did have. It's contained in paragraph 35. The references and premises, I've just said, to the premise of the referred question. And I made the point earlier that when the ECJ sought to address temporal issues, it made that very plain. And particularly at paragraphs 91 and 93, pages 1175 and 76, where they're dealing with Article 33.2, where there is a need to carry out a fresh, updated assessment of whether there are still public policy grounds for expulsion when enforcement is deferred. And if you look at the United Kingdom government's observations, they also are couched in the present tense, but that present tense denotes the material date position in 2007, and we see that from page 1008. This is tab 1 of the supplementary bundle, at paragraph 5. That's what the UK is arguing. So it's the usual analysis at paragraph 4. No permanent residence right before April 2006. Dias on acquere. This is 4 subparagraph 2. The decision was made 2007 before he could have acquired. It follows that he does not qualify.
Yeah, that's, you say that's a non sequitur because 11 years have passed since then, for most of which, for more than 11 years during which he's not been in custody.
No. I'm making the opposite point. My learned friend agrees with me that it's open to me now to argue that he might have it. But if the natural reading of this is they're looking at the past situation and operation of a rule of law, bright line rule of law, the fact of historic imprisonment, they're saying he doesn't qualify. And then when they're looking, when they refer to the present date, the UK makes it clear. Look at paragraph 6, please, my lord. The contrast couldn't be clearer. So one can bend over backwards and try to accommodate a bright line rule in paragraph 42 of the Grand Chamber, but we say that is not a proper reading. Can I just quickly turn to the Advocate General? It's at paragraph 33 of the Advocate General in Vomero, and you have that at 1142. Now, he advances 6 propositions in support of the idea that there isn't a bright line rule, we submit. The first proposition is that even in the case of third country nationals who fulfill conditions of minimum presence on the labour market, rights are based on the Turkish Association Agreement, the court has held that imprisonment does not affect the right of residence. Then the second proposition is that in taking that approach, the court looks at the wording of the relevant instrument, which doesn't permit limitation on the right of residence except in the case of absence or on public policy security grounds. So that is redolent of 16.4. He says, but in Dias, the court held that a similar provision in the directive may be applied by analogy to pre-transposition periods which don't amount to legal residence. It was addressing a lacuna, a situation which could arise only pre-transposition. The case law that he cited concerns the effect of imprisonment on acquired rights, while on acquire relates to the stage at which a right is acquired. That's very important. And then this is the heart of it. Consequently, the main reason cited by the court in on acquire, that's paragraph 26, that's the paragraph my Lord Mance was referring to a moment ago when they referred to Dias. So paragraph 26, according to which the taking into consideration of periods of imprisonment for the purpose of acquiring an RPR would be contrary to the aim pursued by the directive, cannot be applied to the case of forfeiture of that right, because in some cases it might involve a union citizen taking advantage of, which means relying upon, not periods of imprisonment directly, but of earlier periods of residence in the member state, ex hypothesi lawful residence in the member state, because they're dealing with a situation where he's got RPR. So there is no bright line rule, he is saying, in the imprisonment context where forfeiture is concerned. The bright line rule in category 2 cannot be applied. Those are his words.
Sorry. Let me just deal with this stupid thing. Can you take it outside?
So it cannot be applied. The rule in category 2 cannot be applied in category 1. There's no distinction between pre and post transposition. He doesn't make a distinction there. And there is an echo of what the court said about the impact of imprisonment on enhanced protection in 71. If you're looking for a link, it's also there in the Advocate General. And what on acquire had said at 26 was that prison sentence shows conclusively, that's my additional word, the non-compliance by the person concerned with the values expressed by the society of the host member state in its criminal law, etc.
It will also, I mean, the point the Commission makes is that like absence, it's you're not resident in a way that meets the requirements of Regulation 7, of Article 7 rather, of the directive.
Yes, but
but you're not available for work, basically, or as a family member.
But clearly that wouldn't, it would make no sense for that to be the position post-transposition.
Yes.
It would just completely destroy the rationale of the concept totally.
Yeah, we're
in pre-transposition. The question is, how widely do you read that, right? And we say you should read it narrowly. When they say called into question or affected, in that context, those words should be read narrowly. Right? They don't suggest an automatic bright line rule. In the LaSalle context, it's different, because LaSalle concerns absence. So those words can mean a bright line rule. You're dealing with absence. They are applying a bright line rule in LaSalle because it's about absence. It's 10 months absence. She wins under an analogical application of 16.4. The second, I'm going to shoot through the rest of my submissions. The second point that we make, I'll just give you the reference if I may. The bright line rule is inconsistent with previous Grand Chamber authority, Sakaridis and PI. And we dealt with this perhaps best in our printed case at paragraphs 36 to 38. MS 137, that's Sakaridis, and PI is paragraph 58, MS 141. And the point there is that you've got 34 months in Sakaridis, this is paragraph 38, the 37 of the printed case. You've got 34 months combined absence and imprisonment, no sense that RPR is lost. I agree it's not argued, but make the point about consistency.
But that's a different case, isn't it? Because Zacharidis, the period of 34 months commenced in October 2005 and expired long after the transposition date. So if there is a difference in regime between pre- and post-transition cases, this falls into a post.
Except that LaSalle also straddles a transposition date, and they appear to regard that as a transposition, as a pre-transition case. LaSalle straddles the period too. So I don't think that's an answer. And then we make the point that Grand Chamber decisions should be given more weight. Obviously, we're not in Strasbourg territory, but we respectfully submit it as a matter of common sense. They're more authoritative. Professor Tridamas tells me that less than 10% of the cases heard by the ECJ each year between the 5-year period 2013 to 2018 were heard by the Grand Chamber.
No, but LaSalle is a different case because the only gap there was 10 months, which admittedly straddled the transposition date, but is irrelevant because it didn't amount to 2 years. And
it's only irrelevant because the court said that 16.4 would be applied to both periods before and after. The government was arguing, Mr. Palmer, this is my third proposition, which is that there's a difference in principle between Category 1 and Category 2. Melinda and French says all the cases concern acquisition. Formally, that's correct, we accept that. And these differences are ones of fact and not legal principle. That's Melinda and French's position. We say, yes, they're about acquisition in formal terms, but how you get there is important and different. And you can't just ignore history. It's very clear that there's a difference in legal principle for the reason you just raised, my lord. In LaSalle, there's a 10-month absence. The UK argues for 16.3, which is about acquisition, pre-transposition, the residence, but they argue for 16.3 being applied, which would permit them to say it's more than 6 months.
I don't think it did. It was common ground that...
No.
You look at paragraph 45.
47, my lord.
Well, 43, they say it's common ground that Mr. LaSalle's temporary absence do not fall into any of the categories set out in 16.3. So the argument was purely and simply in terms of 16.4, and it failed. The argument was that in a case where the 5 years were mainly pre-transposition, in fact exclusively pre-transposition, the 16.4 was irrelevant, and they said it was only irrelevant because the delay didn't amount to 2 years.
My lord, 45, they say 16.3 is irrelevant.
Yes.
If it had not been, the UK could have said she's been out for more than 6 months, therefore we're going to use the rule in 16.3, which is about acquisition, to say that she doesn't have RPR. Yeah. The court says, no, it's irrelevant. You apply 16.4, she hasn't been out for more than 2 years, therefore she has RPR. Yeah. So it's not just a difference of fact, it's a difference in principle. It would have made a difference to the result in LaSalle. See paragraphs 45 and 47. And we make what I think is perhaps a bit more than a jury point at our paragraph 8, where we show you what the Secretary of State himself was arguing before this court. He was saying that FV had established a permanent right of residence by 2002. That must be a reference to notional residence. The fourth point, if I may just... I'll eat into my reply time, because it's only 10 minutes before the fourth point that we make is that whilst imprisonment appears to attract a bright line rule in Category 2 cases, that's on acquere, it doesn't do so. At least that's the better view. There's a better way of reconciling the authorities to say it doesn't do so in Category 1 cases. I've shown you, Grand Chamber, in our case, the nature of imprisonment that they consider is the case, and given the language of Dias. I won't take you through that again. You've got the references at paragraph 61 and 63 and 65. And now, given the interrelationship between RPR and the enhanced protection, and just by way of conclusion, I mean, the abuse point I've made as well. Just by way of conclusion, we reiterate the imperative need not to construe this instrument restrictively. There are perhaps 4 relevant situations. A true acquisition of RPR case. This is the Onoquere case. There is a bright line. The language of the court is clear. Imprisonment can't count. It interrupts continuity. That's Onoquere. The second position is where there is a loss of RPR post-2006. There is a bright line there too, contrary to what my Lord, with great respect to him, contemplated at paragraph 11, and what was floated by my learned friend. There is a bright line. Imprisonment cannot lead to loss. Shall only be lost, that's by absences. So there's a bright line there. Where
do we get that from as an authoritative point?
From the wording of the directive itself, plus the fact that the directive can't be construed restrictively, plus, if you're interested in Mr. Wilderspin, he was with us on that point for the Commission. But it's the wording. I mean, shall only be lost.
Well, the difficulty about that is they've qualified the word only already. They've read Article 16.4 as...
And I keep going back to the point. Yeah. How far do you take that?
Right, yeah. But it does mean that the word only is not an absolute.
And a logical application.
Yeah.
Then, with enhanced protection, clearly there's no bright line. The broad question is, do previous integrative links remain intact? And then the issue with which we're concerned, which we do say is about virtual acquisition and virtual loss of RPR prior to transposition. And we say that should be on the enhanced protection end of the spectrum. The issue is similarly, do previous integrative links remain intact? It's open on the case law. It makes sense to avoid harsh results. Harsh results are perhaps understandable at the point of acquisition of rights, far less so when forfeiture of rights is concerned. There is a premium on the justice of the case and flexibility and nuance, especially where the impact of imprisonment is multi and not unidimensional, the crooked timber of humanity. Out of timber as crooked as that from which man is made, nothing entirely straight can be carved. Imprisonment, multi-dimensional. Those are my submissions. I'm sorry to have gone over.
Thank you very much indeed, Mr. Hussain. I think we better get straight on.
I'm so sorry. I'm so sorry. Do you want this as
well? My Lady, I'm grateful. In my respectful submission, Lord Reid was precisely right in the comments that he put to Mr. Hussain during his submissions about the effect and meaning of paragraphs 41 and 42 of the court's judgment. They are referring to the question as put in paragraph 40, and they are referring to that issue from an EU law perspective. What I mean by that is this: it's a feature of our domestic immigration appellate structure under the legislation which Parliament has devised, that we are still here today, 10 years and more later, debating the lawfulness of the tribunal's original decision to proceed by assuming that Mr. Vomero enjoyed full 10-year protection. That is the issue.
You say assume, it wasn't disputed.
Well,
it wasn't disputed that 10 years, there was 10 years.
It wasn't disputed then, but
the only issue was imperative grounds of public security.
At that time.
Very well.
And, but that was the basis upon which there's been appeals on the grounds of law. And since future appeals beyond the tribunal level are restricted to those points of law, we are still concerned with the lawfulness, the correctness of that underlying consideration of Mr. Vomero's case. But if and when Mr. Vomero's case is remitted back to a fresh tribunal to reconsider the point, it will be considering matters as they stand in 2019 because of the passage of time and because Mr. Vomero is entitled, under EU law, to an assessment of the proportionality of his removal as at that time, regardless of the level of protections he enjoys. If by that time he has acquired a right of permanent residence, which he may or may not have done, this court does not know, the Court of Justice did not know, then he will be entitled to the level of protection under Article 28.2. It is perhaps surprising to European eyes that we are not concentrating on that question now, or we're not concentrating on that point now. What level of protection does he have, rather than the question of what level of protection did he have some 10 years or more earlier. But that is a feature of our domestic system, but it's entirely unsurprising that the court should say, well, we don't have that information. We are going to proceed on that premise because that is the basis upon which the question referred to us has been put. But what it is emphatically not doing here is answering a different question altogether, least of all displacing what I say the Supreme Court was right on the last occasion to say was clear, and hence did not refer a question on this issue. Least of all, overturning what the Commission accepted was right in terms of the Supreme Court's conclusions. And least of all, as Mr. Hussain would have it, reversing, or I would say the effect of Mr. Hussain's submission is depart from its previous conclusions in Diaz and Onukuri. This would be a silent sidewind by which all of that was displaced by reference to those obscure, non-specific words.
Why are you referring to on a query, which is a clear acquisition case, in circumstances where we are considering loss following 5 years clearly established residence?
My Lord, I don't accept that we're considering loss. In my submission, these are all acquisition cases. The distinction which my Lord has just drawn is a distinction at the heart of Mr. Hussain's case, what he refers to in his submissions as the principled distinction. And my submission is yes, it is perfectly possible to draw the distinction that Mr. Hussain does, but it's not the distinction that he needs. The distinction he draws, which is a perfectly plausible distinction to draw, is that there is a distinction between a first case where there is 5 years continuous legal residence followed by 2 years absence or non-legal residence or imprisonment, all pre-transposition, all pre-2006, on the one hand. And secondly, a case where 5 years continuous legal residence has never been completed in the first place. But my case is that by either of those routes, the result is that person has not acquired a right of permanent residence. The distinction he needs to draw, but cannot, is a distinction between the effects within the first category of absence on the one hand and non-legal residence or imprisonment on the other. Because my learned friend accepts, as he must accept, that in a LaSalle case, an absence case, 2 years of absence pre-transposition means that a right of permanent residence is not acquired. It doesn't mean it's lost, because it didn't exist pre-transposition. It just means on the date of implementation, the 30th of April 2006 in the case of the UK, that right is not acquired because as at that date, when the right is created, that individual does not qualify for it. They've lost nothing, they have acquired nothing.
I'm not sure that he does accept that. I thought he called it into question. i.e. he pointed to the use of the words call into question in paragraph 56 and said that the references to the temporary absence being less than 2 years were not suggesting that if it had been more than 2 years it would have been fatal, but simply that it would have been questionable whether it was fatal, and you undertook some... I think that's his argument, isn't it? And we can argue about...
Well, I had understood him to accept it in the case of LaSalle. If you look at the heading on page 1104, that's the heading above paragraph 14 of his submissions. He says, no bright line rule other than in LaSalle and on inquiry.
I see. So
LaSalle belongs to his category 1, on inquiry plainly belongs to his category 2, but within category 1, I understood him to accept a bright line rule in LaSalle, and he says at his paragraph 19, which is on the following page, he says, which is to make a further point on LaSalle, that case concerned absences. Article 16.4 was therefore directly in play.
Yes, I see. So that
He goes on, says it was accordingly not establishing a bright line rule, it was contemplating the application of one that exists on the face of the directive. So I think by that he means not that there isn't a bright line rule, but the court itself wasn't establishing it, it was simply applying it on the face of the directive. And I say that's wrong. I'm going to go to LaSalle in a moment. Because this court specifically says Article 16.4 does not expressly apply, as indeed it doesn't, because 16.4 concerns the loss of an acquired right of permanent residence. What it does say is impliedly you have to apply it to make sense of the purpose, if you like, the policy of the legislature in creating this right, because otherwise you could have someone relying on 5 years continuous lawful residence in the dim and distant past, who've been absent for decades, and come and claim a permanent right. There has to be a cut-off. And so the cut-off they apply is the same cut-off that would apply in the case of someone who had acquired a right of permanent residence and then loses it by reason of 2 years continuous absence. That's the route by which they get there. And then the significance of Dias is in the context of pre-transposition non-legal residents. They use the words apply the rule. My friend says it's not clear. You need clear words. I say the words are perfectly clear in Dias. By analogy, they apply the rule.
Can you just help me on one thing? I mean, what you've been saying perhaps shed some light on the meaning of call into question in Dias, because that phrase is also used in LaSalle, which is a bright line case. But the loosening of the link is another phrase which appears in LaSalle, and it refers to the Council's statement of reasons for common position with a view to the adoption of the directive. Was there anything, did you look at that, was there anything in that statement by the Council of their reasons which threw any greater light on the...
Well, I confess I haven't been back to that this time. No. But the words loosening the link are the words which then run through into Dias and also into the imprisonment cases. Yes. Because underlying that is a recognition that over time what the scheme of the directive is to confer increasing levels of rights, increasing levels of protection against removal as rights are exercised and as integration deepens. And all the cases, in particular the cases on the 10-year rule, MG and now B, are concerned with the circumstances in which it can be concluded that notwithstanding long residence, by virtue of imprisonments, those links have been loosened. That level of integration is undone, which means they no longer qualify for that top level of protection. And that's one of the reasons why, in my submission, it is impossible to distinguish in principle between the effects of transposition, absence, non-legal residence, and imprisonment. Because in each case, what the Court of Justice has done is analyse the effects of them as loosening links. And what you're left with in each case is a bright line rule, which is unsurprising, because as my friend accepted at the very close of his submissions, although in terms of loss of rights, bright line rules can be unjust, they're not in terms of acquisition of rights. There's also a measure of administrative practicality about this. People and legal certainty. People want to know when they have acquired a right, and the authorities need to recognize when someone has acquired a right. And the means which the EU legislature has adopted in Article 16 in establishing the right of permanent residence at all, gaining it under Article 16.1 or 2, and losing it under 16.4 once it has been acquired, is in each case bright line rules. 5 years, 4 years and 11 months won't do, 5 years will. 2 years absence is fatal to an acquired right, 1 year, 11 months doesn't displace it at all. These are bright lines which are imposed, and they contrast with the situation which is applied on removal of someone when someone is sought to be deported by the authorities, where in each case you get a fine-grained personal examination of their case. Article 27, Article 28 requires a detailed consideration of the circumstances of the case, of course an assessment of proportionality, and in circumstances where someone has 10 years residence before the date of decision but has been in prison during that time under the authority of MG and now B as well, you have to adopt a sort of fine-grained analysis and integrated assessment of their personal circumstances to work out whether or not they have lost the protection of Article 28.3a. So that's very detailed. Often you can see that being argued in courts on appeal and so forth as to whether someone does or doesn't qualify for that right of protection. That's obviously completely impractical in circumstances when the great bulk of people are simply acquiring a right in the first place, where it's dealt with in each terms by simple length of residence or length of absence. And now, in these pre-transposition cases, of which there can't be many left, but in these pre-transposition cases, equally 2 years absence, 2 years non-legal residence, and 2 years imprisonment. They're bright line rules determining whether or not someone acquires the right of permanent residence in the first place. So that is the distinction which needs to be drawn by my own friend, that somehow absence falls to be treated differently from non-legal residence. And I say that's not borne out by the terms of LaSalle and by the terms of Diaz. And I appreciate the court's now very familiar with these authorities, so I won't labour my way through them. But if I can quickly point you to some key passages in both. LaSalle, first of all, which is at tab 8, and the relevant passage begins on page 761.
I mean, the fundamental difference is the transposition date, is it? The directive comes into force and then states are entitled to look at the position in the way you've described up to that date. Thereafter, the ball game completely changes, and the only thing that is really fundamental is if you leave the country voluntarily for 2 years, then you've lost your permanent right of residence. Yes. If you are just in the country without exercising an EU right to work, that's irrelevant because you're entitled to do that. And the Commission's view, contrary to perhaps the very provisional view we expressed, was that imprisonment possibly even could be said to deepen the integrative link. But anyway, you're not in the same position as someone who's absent. No, probably.
And I'm not going to seek to persuade this court to take a different view from that which the Commission expressed on that occasion, because it's irrelevant. It's not an issue and it's irrelevant. But secondly, as a consequence of the Court of Justice's actual finding, which you have to have a right of permanent residence before you can enjoy the protection under Article 28.3a, it would severely limit the number of people who could in fact enjoy the protection of Article 28.3a if they lost that right of permanent residence after 2 years imprisonment. It's difficult to see both those propositions holding true. I did run both, my own friends are right to say, I did run both in the alternative last time, but having succeeded before the Court of Justice on that main principle, I'm not going to seek to persuade my lords of the first proposition as well, but it's irrelevant. But my lord is right, the situation is dramatically different, and the reason is post-transposition, the moment you clock up 5 years continuous legal residence, that right crystallises. You don't have to apply for it. You have to apply to evidence it if you want a card to say so, but you have that right as at that point, automatically, directly, under EU law. But of course, that obviously was not the case pre-transposition, because the right didn't exist. And instead what happens is automatically on the 30th of April 2006, if you had qualified, then it clocked up automatically. And that wasn't a case of ignoring history, as I was accused of. Of course one shouldn't ignore history, but nor should one choose from it selectively. You look to see if there is a 5-year period of legal residence continuous, and if there is, you look to see if since then there has been 2 years or more absence, non-legal residence, or imprisonment. At that point, the effects, as it's put in fact at paragraph 38 of LaSalle, on the preceding page, 760 or 38, this is not a question of the directive having any retroactive effect. It simply gives present effect, as at that date, to situations which arose before the date of transposition. So you're not looking at part of those situations, you're looking at the whole picture.
Well, the principal argument in LaSalle wasn't it, that nothing that happened before the date of transposition was relevant at all?
Yes, the Secretary of State's principal position was, at that time, was that the time didn't even begin to start clocking up until the 1st of May 2006, and so you qualified in 2011. That was wrong. And then it was that if time before began to run, it was only if it ended after April, it had to be continuous up to that point, and that was wrong. But, as they made clear in answer to the second question before the court, if there had been a gap of 2 years, which wasn't Miss LaSalle, it was only 10 months in her case, but if there had been a gap of 2 years, then that individual would not have acquired. And of course you can see it's a bright line rule, because rather than considering the precise circumstances, the extent of the significance of 10 months, they simply say, well, it's less than 2 years. 2 years being the obvious cut-off point. And if I may just run through some points, I can deal with this quickly. Of course, it's right to say at 45 that Article 16.3 was irrelevant, but that is because, as you see from the following sentence, 16.3 is concerned about disruption of continuity. That's what 16.3 is concerned. It's answering the question, what interrupts continuous? What does continuous means? If you're absent for short periods of under 6 months, that doesn't disrupt the continuity. But that's irrelevant because, as you see in the paragraph before that, beginning of 44, it's common ground that she had legally resided for a continuous period of more than 5 years. So as soon as you've acknowledged that, and as in answer to the first question, you say it all counts, even though it's pre-transposition, then of course 16.3 becomes completely irrelevant. Then at 47 to 48, on the subject of 16.4, I can go to 48. It is, of course, true that, as pointed out in 38 of this judgment, that's the paragraph to which I went a moment ago, insofar as the right of permanent residence provided for in Article 16 may only be acquired from April the 30th, 2006, it does not expressly follow from Article 16.4 that citizens of the unions who have resided for a continuous period of 5 years may rely on their connection with the host member state in order to avoid their temporary absences of less than 2 consecutive years prior to April 30th, 2006, preventing them from acquiring the right of permanent residence, which is a rather garbled way of saying, of course it's not right that they can simply point to Article 16.4 and say, look, that establishes that the rule is 2 years, I've got 10 months, that's less than 2 years, so I haven't lost anything. The court's acknowledging that. That's because it doesn't expressly so provide. It's only expressly concerned with the loss of an acquired right. But what, of course, it goes on to say is that when you look at the reasons, paragraph 50, given, and the objective, 53, the objectives and purposes, and at 56, the concern in the final sentence there that must necessarily apply to these periods, because if not, they'd be required to grant the right of permanent residence, even in cases of prolonged absences, which call into question the link between the person concerned and the host member state.
So less than 2 years doesn't affect it?
No.
Where do they say more than 2 years would destroy it?
When they say that Article 16.4 must necessarily apply, and Article 16.4, of course, is concerned with a period of 2 years or more. That's in paragraph 56, and then in 57, it follows that Article 16.4 is to apply to continuous periods of 5 years legal residence completed and before April 30th, 2006, and in application implies, so it's not expressed, but it implies in particular that absences from the host member state of less than 2 consecutive years occurring after the 5 years are not such as to affect the link of integration of the citizen of the union concerned. So, of course, I accept that it does not put it there in the converse, that more than 2 years does, but that's the inevitable inference because that is what 16.4 says, and because this is a case of 10 months absence, and they've judged it by reference to that 2-year threshold. So then when one goes to Diaz, which is behind tab 10, and the relevant passage begins from page 829, we see the question that was before the court at 40 and 41, again framing it in terms specifically at 40 on the basis that since the right of permanent residence could be acquired only as from April the 30th, and then 41 posing the question, in effect, what is the effect of non-legal residence? That question is dealt with from paragraph 56 onwards, having reached the conclusion on the prior case advanced by rejecting a submission by Ms. Dias. 55, concluding that legal residence for this purpose means in accordance with the directive.
And just as Ms. Dias didn't meet those conditions, equally somebody in prison wouldn't meet those conditions either.
That's right, that would be my submission. It's exactly the same. But Diaz was not an imprisonment case, I fully accept. And you can see from paragraph 23 that we were concerned with a period of about a year within her 5 years residence when she was, after her 5 years, yes, after, sorry, I should say, but within the period before transposition, she had about 12 months, but all other times she had been working or on maternity leave, and still a worker. But then
it's her so-called third period.
It's her third period, it's referred to there. It's 12 months in length. And from 56, we see that the question which the court then asks itself is precisely the same as the question it asks for itself in LaSalle, only substituting non-legal residence for absence. And 57, making clear that it had not been acquired, the right had not been acquired, notwithstanding all that lengthy exercise of legal rights before 2006, because it couldn't be. And that final sentence, beginning consequently, making that expressly clear.
I don't know, but perhaps it might be helpful to see on page 824 the conditions for legal residence are set out in Article 7. And over the page, I think one finds, yes, the circumstances in which, even if you're no longer working, you retain the status that would qualify your residence.
Yes, indeed.
And
it appears on the facts of this case, rightly or wrongly, that the tribunal, the Social Security Commissioner, rather, had treated that period of a year of not working as non-legal residence. That there might have been an argument that actually she continued to be a worker, in fact, but that wasn't. The court didn't go behind that, and I don't need to either. It took that finding and addressed it on that basis.
Yep.
58, I just point out that we're explicitly at all times dealing with the language of acquisition. You see that twice. we see that 59 then recalls Article 16.4, if you like, in its pure form, just reciting what it says about the loss of the right once acquired.
But the interesting thing is that it uses, it says categorically that LaSalle is a bright line test, doesn't it? It
Yes.
should be borne in mind, first of all, the court has already ruled that Article 64 refers to loss of the right by reason of absences,
Yes.
and that such a measure may be justified. This is the underlying justification, because after the absence of that jurisdiction, the link is loosened.
Yes.
And
And then in 60, it recalls the prolonged absence point as further justification for that. So it's recalling all this logic of LaSalle, which my submission it then applies without distinguishing between the two cases. At 61, again, it's using the 2-year cut-off, and again using the language of whether something is acquisition, whether the right has been acquired. And then at 62, we get to the crunch. Such reasoning, i.e. all the reasoning in LaSalle, must also be applied by analogy to periods of residence completed on the basis solely of a residence permit, but non-qualifying residence, which occurred before April the 30th, but after 5 years residence. And at 63 to 65, explicitly finds these situations are comparable. So at 63, 16.4 refers only to absences, but the integration link is also called into question in the case of a citizen who, having resided for 5 years, then decides to remain without having a right of residence. Pausing there, you can't load too much onto the words call into question in this paragraph, or indeed elsewhere, because 63 doesn't refer to any particular length of time. So it says as soon as someone's non-qualifying, well then you have to look into it because their residence, their rights, their integration link may have been loosened. In 64, it should be noted, integration objectives, looking at the qualitative elements relating to the level of integration. Again, this is the language we get later in the imprisonment cases. And then 65, as the situations are comparable, that is, absence and non-legal residence, pre-transposition, it follows that the rule laid down in Article 16.4 must also be applied, by analogy, to periods in the host member state completed on the basis solely of, etc., not effectively non-legal residence after a continuous period of legal residence. Now, I say that is completely unambiguous and clear. That rule must be applied. It's not what the rule says in 16.4, as we all know, but it's being applied by analogy because of the underlying logic of the directive.
which is also what Advocate General Tristanjak said in the same case. She said, spoke in terms of a lacuna which had to be filled.
It was. The lacuna is the complete absence of any transitional provisions in the directive at all. All these cases arise because there were no transitional provisions at all in the directive, and so the courts have had to fill that gap and work out what they are.
It's not the only one.
Equally, no, it's not. Equally, there's nothing in the directive about imprisonment at all either. It's just not mentioned, and so the court has had to wrestle with how that is to be treated and fill that lacuna as well. And so then at 66, you get conclusion. It follows that periods of less than 2 consecutive years, ... are not such as to affect the acquisition. Again, it's put that way around because this is a 12-month case, but equally the converse must be that 2 years or more does affect it. In other words, it is not acquired on the 30th of April, 2006. And then you get to the point about imprisonment, and I say there's no distinction in quality. And I look to Onukwari in that context, not because Onukwari was what my learned friend calls a Category 1 case, but it's a Category 2 case. That is plainly right. But because in reaching its conclusion on the question before it as to whether imprisonment counted as legal residence or disrupted the continuity of legal residence, the answer was it didn't count as legal residence and did disrupt continuity. But in explaining that, at paragraph 25 of Onukwari, so Onukwari is at tab 14 and on page 903, paragraph 25 immediately follows consideration of LaSalle in the preceding paragraph. There, for the reference for the dependence on integration, and then continuing, such integration, which is a precondition of the acquisition of the right of permanent residence laid down in Article 16.1, is based not only on territorial and temporal factors, but also on qualitative elements relating to the level of integration in the host member state, citing DS at 64, to such an extent that the undermining of the link of integration between the person concerned and the host member state justifies the loss of the right of permanent residence even outside the circumstances mentioned in Article 16.4, referring there to DS at 59, 63, 65, to which I have just taken you. Now, it's right to point out here the word loss is used, but in my submission, what is not being meant by the court here is that they're talking about the loss of an acquired right. They're dealing with the case in front of them, which is the question of whether we both agreed whether a right has been acquired in the first place. So here loss is being used loosely to mean effectively loss of the opportunity to acquire that right. Certainly not talking about a right which is already crystallised but then is lost.
I think that's made clear in the next paragraph.
It is. Just on the last occasion, some emphasis was put on the use of that word loss by my learned friend, so I'm heading that one off. But that is the link, the parallel. And so the inevitable consequence of that, in my submission, is that imprisonment will be treated in precisely the same way as non-legal residence was in Diaz. Indeed, imprisonment is a stronger case. Diaz, imprisonment and a crime which precedes it is positively disruptive of levels of the degree of integration. That is the underlying rationale behind the case law on the 10-year rule, where even if you've had 10 years residence, of which only half need to have been legal residence in the sense of fulfilling the conditions, notwithstanding that, you can lose your right of protection, not through non-exercise of treaty rights, but because you have committed a crime which has resulted in you being in prison for so long. So your levels of integration are loosened by reason of that. So imprisonment is a stronger case than simply non-exercise of treaty rights. But I don't need that point. I need to say only that it's at least equivalent in terms of the effect of non-acquisition pre-transposition.
So if the effect of LaSalle and Diaz is to create a bright line rule for pre-transposition cases, why did the court in Vomero say that it didn't have the information to be able to confirm what we had said in paragraph 12?
Well, it did not say that quite, my lord. And I go back to the outset of my submissions. It used the present tense because, to its mind, the live question before Mr. Vomero could actually be deported is that there must first be an analysis of his present circumstances, not his circumstances 10 years earlier. And that would include, I accept, whether or not at this point he does have a right of permanent residence, to which I do not know the answer, nor does this court, and nor did the Court of Justice. And that is all it is saying. And it's just a feature of our appellate system that we go round in circles for a while before.
I mean, isn't it more likely that the court was in fact addressing the Advocate General Spooner's comments, in which case that's against what you just submitted?
Well,
what was he?
Not. It made those comments in a specific context, which, although the question which this court referred was that narrow question of is the RPR a precondition for enjoyment of enhanced protection, Mr. Vomero's counsel had taken the opportunity to have another crack at the question of whether or not he did enjoy a right of permanent residence. And the Commission had taken the opportunity to have a crack from my Lord's paragraph 11, but having expressly accepted my Lord's conclusions in 10 and 12. And its main concern was precisely to stop the phantom, which my friend conjured earlier, of that idea taking hold, as he put it, that an acquired right could be lost by virtue of 2 years imprisonment.
Why did the Advocate General refer to the Turkish cases if he didn't think they were relevant?
I'm coming to it. I'm coming to it now, my lord. If I turn to the Advocate General, which is Authorities 18 and page 1142. Perhaps I can just go back to the preceding paragraph, actually it's 1141, paragraph 32.
Sorry, in...
I'm in the Advocate General,
Yes, in the Advocate
which is tab 18 in the paper copy, or page 1141. May I be forgiven for just pointing out that the Advocate General here inaccurately records what this court had stated by saying that I note that this case question arises only in Vomero's case, where the National Court has stated that Mr. Vomero has not acquired any right of permanent residence, which is not what this court said. It said it had not at the time of the decision. It says that's a matter for that court to determine. But then it must be, it says, however, it must be noted that. Now, I'm unable to say whether what follows is a response to what precedes it, the apprehension that the court had said that Mr. Vomero has not acquired a permanent right of permanent residence, or whether it's more prompted by the discussion of, in particular, of the Commission about acquired rights not being lost by virtue of imprisonment. But what he does note is that in citizens of third states who fulfill the condition of minimum presence under Decision 180, the court has held that their right of residence is not affected by imprisonment. Pausing that is right, but relates to acquired rights, which it has held and not lost by virtue of being held on remand, by virtue of a suspended sentence, or indeed in one case, which the Advocate General here does not mention, even by virtue of a 3-year sentence of imprisonment.
What do you have to do to acquire the rights under the Turkish agreement?
I can show you that, my lord, very briefly. May I just keep a finger for those in the photocopy? It's page 1345 behind tab 22, but it's a Turkish worker duly registered as belonging to the labour force of a member state, acquires increasing rights of employment and hence residence after a graduated steps up in time. So after 1 year's legal employment, they have the right to renew their permit, their work permit, if for the same employer, if a job is still available. After 3 years, they can switch to a different employer, but subject to the rights of priority of EU citizens. And then after 4 years, they can take any paid employment of their choice. So it doesn't govern their initial right of entry. That's a matter for national law. But after they've done 12 years of legal employment, they get graduated protection to be able to continue to work. So as you complete those periods of legal employment as a worker duly registered as belonging to the labour force, you get those rights. The question which has arisen in various forms is, when someone's sent to prison or is held in remand or is subject to a suspended sentence, do they cease to be a worker duly registered as belonging to the labour force of the member state?
Telling us that the cases where the court has said that imprisonment does not affect them are cases where they have already acquired the relevant 1 year, 3 year, 4 year, whatever it is.
That is right, my lord.
Status.
Yes, that is right. In all of those cases.
So that their loss, I don't like the language much, but in the terms of the language which has been used, they're loss cases rather than acquisition cases.
They are loss cases rather than acquisition. And more to the point, the court has in each case pointed out that under Decision of 180, there is a similar provision to that which EU citizens enjoy under the directive, restricting the circumstances in which they can be excluded to cases where there are reasons of public order, public security, and so forth. And they say that's the only circumstances in which those acquired rights can be interfered with. So imprisonment alone doesn't interfere with them. But of course, if there's a follow-on decision from that saying you are a threat to public security and that's justified and all the rest of it, then of course those rights can be lost and they can be removed. It isn't an automatic consequence of imprisonment. So what the Advocate General here is referring to, first of all, is those series of Turkish cases, all of which one could characterise as lost cases. He makes the point I've just made just above letter D, referring to the wording of the provisions of that decision, which doesn't permit any limitation on the right of residence except in the event of absence or on grounds of public policy, public security, or public health. Well, that is just like the position under the Citizens Directive. Then he goes on, however, in Diaz's case, the court held that a similar provision of the directive, namely Article 16.4 on loss, may be applied by analogy to periods prior to those covered by the directive, which do not amount to legal residence for the purpose of Article 16. We've seen that, that's right. In Diaz's case, the court sought above all to address a lacuna and a situation which could arise only prior to that directive. Pausing there, that is right, but it's also equally our case, Mr. Vomero's case. The case law cited above concerns the effect of imprisonment on the enjoyment of rights acquired after presence on the employment market for a number of years, whilst on Nukwiri's case relates to the stage at which a right is acquired. That's right, of course, but of course Diaz is not. Consequently, the main reason stated by the court in Nukwiri's case, now this reference is not to the paragraph mentioned by Lord Mance and the paragraph I took you to earlier, paragraph 25. It's a reference to paragraph 26. So it's not a reference to the paragraph which brings in the Diaz logic. So consequently, the main reason stated by the court in Nukwiri's case, according to which the taking into consideration of periods of imprisonment for the purpose of acquiring a right of permanent residence would be contrary to the aim, cannot be applied to the case of forfeiture of that right, because in some cases it may involve a union citizen taking advantage. So all of this, when read as a whole, is making plain that in a case where a right has been acquired, it will not automatically be forfeited simply by virtue of imprisonment, absent a decision, whether under decision 182 under the directive, that the presence is contrary to the decision on the grounds of public policy, public security, or public health. But none of this is directed towards the point which we're concerned, which is under what circumstances pre-transposition can a right of permanent residence be acquired, other than insofar as he refers to Diaz. And the logic carried over from Diaz to Nukwiri is not challenged. If it were, he'd be referring to paragraph 25, not 26.
Well, isn't that a bit narrow? I mean, 26 seems to follow from paragraph 25, and the thrust of what he's saying is surely to question our previous approach, because he's really saying, look at a Nukwiri, can you apply that in a case where in reality a right has been acquired or can be seen as having been potentially acquired by virtue of 5 years residence, and the union citizen is relying on those 5 years, those earlier periods of residence in the member state, rather than directly seeking to rely on a period of imprisonment to establish the 5 years, as was the Nukwiri case. So he's saying this case, Vomero, is different from Nukwiri, and the inference is surely to question what we said previously, that it falls into the simple acquisition category.
Well, it may be that the point occurs to him because he is in his mind questioning whether it's right that Mr. Vomero doesn't have a right of permanent residence, but he doesn't actually say anything about that issue. All he says is that you can't read from Nukwiri and the rationale as to why a right of permanent residence is not acquired in an imprisonment case to say that it's automatically lost by virtue of imprisonment. But even the scantest consideration of the facts in this case show that the question with which the Supreme Court was concerned was not that question, but the question of whether the right had been acquired in the first place. And what he is looking at, as we can see from 32, appears to be in the present tense. He's raising the question as to whether he has acquired a right of permanent residence whilst making clear that he would not, if he has acquired it, would not have lost it simply by virtue of his imprisonment.
But why does he say it unless it it makes a difference? That why does he draw attention to the difference between what's being called acquisition and what's being called loss, unless it matters to his reasoning?
Well, the answer to that lies in the very helpful article by Professor Tridimas, which has been provided at tab 28 of the bundle, from page 1568.
28.
It's tab 28, it's right at the back of the bundle.
Page?
1568.
Thank you.
Which is taken from Professor Tridimas's article on the role of the Advocate General in the development of community law, Some Reflections, which was published in the Common Market Law Review in 1997. What Professor Tridimas says under the title, The Role of the Advocate General, may be said that the Advocate General exercises the following functions. He assists the court in preparation. He proposes a solution to the case before the court, which is my Lord's point. He provides legal grounds to justify that solution, in particular relating it to the existing case law. But also he may opine on such points of law incidental to the case as he thinks fit, and may in particular make a critical assessment of the case law or comment on the development of the law in the area in issue. And there's some discussion of that. If one moves on to 1571, where that fourth point is developed, that's MS 1571, the role of the Advocate General is not exhausted in the assistance of the Office of the Court for the resolution of the specific dispute. He may comment on issues which arise from the case, but which are not strictly necessary for the court to give judgment. He performs a wider role to make a critical assessment of the case law, identifying trends, pointing out inconsistencies which may exist, outlining possible future developments. His independence is of cardinal importance, and part of that wider function is to express his own view, criticising where he sees fit principles established in previous cases, even in circumstances where it's highly unlikely that it will be followed by the court, for example, where he disagrees with a judgment. And then where the court remains silent on an issue decided upon by the Advocate General, the opinion is the only existing judicial pronouncement and stands as a legal authority on its own right, and that may occur in 3 cases: where the Advocate General makes an obiter dictum, where the court does not pronounce on an issue because it disposes of the case on different grounds, or where the case is withdrawn from the court after the opinion is delivered. In such cases, the pronouncement of the Advocate General may prove useful in a future case where the same issue falls to be examined by the court. And as Lady Justice Arden, as she then was since commented, none of that is binding, of course. So
we should read the last bit of 33 as just putting down a marker in case the point crops up later.
It's a marker.
Nothing to do with this case.
Nothing to do with this case on analysis of the facts.
Maybe.
It just doesn't fit with the facts. And if he were to consider it fitted with the facts, you could expect him, if not the court, at least him, to say so and to explain why that was so, to engage either with Lord Mance's reasons at 10 to 12 as a minimum, or perhaps what the Commission has said, or perhaps what my friend Mr. Hussain had said. But there's none of that discussion. He doesn't go into it. He simply makes clear forfeiture or loss cases are different from acquisition cases, and that's perfectly consistent.
Mr. Palmer, you're almost out of time. You've made some powerful points on LaSalle and Dias. You simply haven't had time to address us on Saccharides and PI.
There's a very short answer, so I can deal with that.
Do.
Very briefly indeed. It is provided in my submissions, tab 9 of the supplementary bundle, at paragraph 37, which begins on page 1098.
Yes.
But the key point, for present purposes, is at the top of page, following page 1099, beginning but in point of fact. And that is that Mr. Saccharides had acquired a right of permanent residence on the facts on the 30th of April, as recorded in the judgment, as he had been legally resident in Germany for his entire life, as at that date, barring only periods of absence, of which there were 2, but neither exceeded 2 years, they were considerably shorter. And the case was approached on that basis.
So they're not pre-transposition cases?
They're not pre-transposition cases.
But we'll have to look at that.
On the magic date of April the 30th, 2006, when I accepted earlier, any right would have crystallised. He had been absent only since October 2005, so 6 months. So well below the two-year threshold. He'd had an earlier absence as well for a period, I think, of 5 months on the facts, this is 6. So in neither case did that displace his lifelong residence in Germany. So he acquired that right. Of course, there was then a further period in which he remained overseas, and then he was arrested and so forth. But even that came in below 2 years. And the same is true in PI. He'd lived in Germany since 1987. He was arrested in 2006, in April 2006, but would have acquired a right of permanent residence at the end of that same month.
So you can distinguish those much more easily once you've abandoned what we floated in paragraph 11 of our judgment.
It would create a difficulty for that alternative submission, yes.
Yes.
Yes,
But not this. So I think that concludes what I had to say, other than simply in 10 seconds to say that we don't accept what is said, and my friend's point that this approach undermines the effectiveness of Article 28.3a. The court has concluded the right of permanent residence is a qualification. It's not possible now to keep people in custody before making a decision to deprive them of the right of permanent residence. These are all pre-transposition cases only. None of that arises. There must be very few of these cases. Nothing the Secretary of State can now do to manipulate the situation in the way that is suggested.
Apropos that, it's accepted, of course, on both sides, this case has to go back to the tribunal. We've been arguing about whether it's open to debate before the tribunal whether a right of permanent residence had been acquired on the date of the Secretary of State's decision to deport. You said, when talking about what the Court of Justice was referring to in paragraphs 40 and 41, that they, of course, were thinking of the present. Now, when the case goes back to the tribunal, will the question still be the lawfulness of the decision when it was taken in 2007, or will it be open to the tribunal to ask itself, has a right of permanent residence been acquired since then?
It won't purely be a lawfulness in a narrow sense as considered by the higher courts, of course, because a proportionality assessment will be undertaken.
Well, yes, that's...
And that will be by reference to then current circumstances, not by reference to the circumstances.
So if he has a right of permanent residence now, that will affect the proportionality.
It will affect the
under 28.1.
It must do.
Yes. It doesn't give him the enhanced protection under 28.2, still less 28.3.
Well, not in relation to that initial decision. If the court considers this next point important, I'll have to confirm my instructions. I don't know off the top of my head, but I think I'm right in saying that because so much time has passed, there may have to be a subsequent decision if it's applied for. I think those who are more familiar with the nuts and bolts will be able to supply that answer by the sound of it. But after a period, an application can be made to say, please take a new decision now. And the right of appeal would arise from that decision. But so far
just looking at the body language in the court, it looks as if, yes, it has arisen and yes, it will be made. Yeah.
I have no doubt.
If that's the situation. And then, of course, that will have to be made in the light of the...
That will then be made. So this decision, no, that the key point is 2007, because, of course, if he did enjoy a right of permanent residence, he'd be entitled to argue about 28.3a, which runs back 10 years from the date of decision.
Yes, we do understand all of that.
So, but there may be further decisions in due course. So there's a lot of water to flow under the bridge yet in this case. But the narrow issue before my lords, in my submission, should be answered as we propose, and be remitted back on the basis that at least is decided that there was no right of permanent residence at that date.
Yeah.
Great.
Thank you. Thank you. I'm not sure you get a right of reply, Mr. Hussain, but you could have 2 minutes.
My lady, on the point of the binding nature or otherwise of the ECJ's judgment, Lord Mance's point, we say ECJ judgment provides interpretation of EU law. Where it interprets EU law, that interpretation is binding by virtue of the rule of primacy. ECJ can obviously reformulate the question. The key, we say, to the issue is the Vomero judgment at 41 to 43. The ECJ is not a court of application. It is an unnatural reading of 41 and 42 to read it as referring to the present day without specifying what that is, hearing or judgment. The Attorney General, the Advocate General provides very important context. The only answer, with great respect to him, that my learned friend has about that is that, look, those cases are dealing with acquired rights. But we say, this is my second point, first point was about Vomero. The second point is that there is a distinction in principle very clearly. My client's case is in substance a loss case. Formally, it's about acquisition, but it's in substance a loss, and that's why the Advocate General's observations are germane. The third point, I hope your Lordship's Ladyship will recall that I said the better view was that there was no automatic loss, and that is because there is an argument available to my learned friend on the language of LaSalle and Dias called into question. We say that the context is different, very different in Dias, because you are dealing not with the application of a bright line rule in 16.4, but a creation of a new application of 16.4. And the question is, how broadly should that go? The language is to be contrasted with the language in Vomero, where the court talks about destruction and links being broken, albeit in the context of 28.3. You don't have anything like that in Dias. The fourth point is that there was certainly not intended in LaSalle to be this great dramatic difference between pre and post transposition cases. If you look at paragraph 56 of LaSalle, they are saying the opposite. They're saying 16.4 should apply independently to pre and post 2006, the point that my Lady Justice Ardner, she then was made in the referring court. And paragraphs 31 to 37 effectively are directed to the same thing, do not have this great dramatic difference in those two categories of case. Can I just please invite your attention, I won't take you to it, to paragraph 26 of our submissions at page 1107, where we say that, where we advance reasons as to why you should not interpret Dias, still less on Aquaria, setting up a bright line rule. Fourth point, moving to Dias itself, 65 of Dias doesn't say that they're the same, the context is the same. It says that they're comparable. That leaves at least some room open to me to be able to say that given you're applying the rule by analogy to a comparable but perhaps not equivalent context, that there is some room to be able to say, well, it's not the same bright line rule as you had in LaSalle. On Aquaria, the sixth point, imprisonment, we know, can actually lead to integrative links being strengthened. That's what Sakaridis said long ago, and it's a passage that's quoted in our Grand Chamber case, Vomero, at paragraphs 73 to 75 that I took you to earlier. The bridge between Onekure and our case is, of course, the Advocate General, where he says Onekure should not be applied to forfeiture cases, and we would say not simply formally forfeiture cases, but also substantively forfeiture cases, which is what this is. Seventhly, PI and Sakaridis, we resist the idea that these are straightforwardly non-transitional cases. If you look at the periods, you'll see they straddle the transposition date, as indeed did LaSalle, and that was treated as a pre-transposition case. In terms of abuse, if Melanophen abandons his nuclear argument that 16.4 can be read as only can be written away, can be finessed away, even in post-transition cases, then I accept that the potential for undermining is restricted to cases where the imprisonment occurs after the 30th of April 2006. But it doesn't matter if it's deliberate or if the effect is that the protection is undermined. If there is a delay, not a deliberate one, then that has the potential to stop in its tracks eligibility for enhanced protection because 2 years imprisonment have been accrued by reason of a delay. And that is a situation which ought to be avoided given the prohibition on restrictive construction. Those are my submissions.
Thank you very much indeed. Well, you've all got through a lot of material in a very short time, and now we must go and work out what to do with it. Thank you all very much indeed. Court is now adjourned.